right, everybody. I'm Shanna Welsh-Levin, your Southern California real estate attorney. Here at SoCal Realty Law, we protect the value of real estate investments by removing unwanted tenants, conducting successful transactions, and pursuing justice for property owners who were harmed by others. As you know, we've been providing these webinars since 2020, almost every month, and I enjoy doing this. It helps keep me well informed and helps keep you well informed. So I'm excited to do our topic today. Before I start, please keep in mind that what I am presenting today is not intended to be legal advice relating to any specific topic. We are just providing some information and some guidance. The majority of what I'm talking about is primarily relating to residential landlords and residential tenancies. We're not covering mobile homes or commercial tenancies. All right. So the topic for today is exploring different types of rentals and options for landlords. In particular, as a general overview, we're going to cover short-term rentals versus college rentals versus executive rentals, and then regular long-term leases. And any combination of these. We'll look at California regulations that apply differently or the same to each of these different subject matters, weigh the pros and cons, look at some things that should be in your leases, like notices to tenants that are required in California for regular leases. I have a comparison table for the 4 types of tenancies that we're talking about. And then at the end, if we have time, we'll do some Q&A. As I was preparing this outline, it just got longer and longer. There's a lot to cover here, but I will try to save some time at the end. So to start out, we'll talk about short-term rentals. What's the definition of a short-term rental? Occupancy by the tenant, although short-term rentals, we will identify the difference between tenant and lodger, but occupancy has to be for 30 days or less in order to qualify as a short-term rental. The owner has to pay transient occupancy tax, and that is pursuant to the Revenue and Taxation Code Section 7280. So transient occupancy tax may be charged by any city or county. It's not charged by the state, although it is paid to your city or county for any living space that is used for occupancy of 30 days or less. It could be a living space, any living space, including a hotel, inn, or a motel. And then the way that the statute is written, it says any living space unless the occupancy is for a period of more than 30 days. The occupants may be considered lodgers in a short-term vacation rental instead of tenants. This means that they're treated like the occupants of a hotel, and that means that different rules may apply. The rules that apply to hotel occupancy may apply to short-term rentals, but they have to meet those 2 requirements. So they have to pay the transient occupancy tax, and they have to occupy for 30 days or less. However, there's some uncertainty with regard to the treatment of the short-term and vacation rentals as lodgers, as hotel occupants. Most vacation rentals don't actually operate like a traditional hotel with the structured innkeeper-guest relationship that the statute Civil Code Section 1865 contemplates. So, and the case law confirms that there is a distinction between the short-term rentals and hotels. In particular, courts have recognized that short-term vacation rentals are regulated differently from traditional hotels, with municipalities treating them as residential properties for the most part, subject to zoning restrictions rather than commercial lodging establishments. So unless your local Your local jurisdiction provides clear statutory guidance identifying short-term rentals as subject to the Civil Code Section 1865. Then property owners, in the absence of a clear distinction or in absence of your local jurisdiction stating expressly that Civil Code 1865, which is a statute relating to lodgers and hotels, also applies to short-term rentals. If your jurisdiction doesn't say that expressly, then you have to assume that your short-term rental is a standard landlord-tenant relationship. So specific lease termination procedures and lease requirements are applicable. We'll talk about this a little bit more in a moment, just with the different definitions of lodger versus regular tenant. Another point is that there is no statewide California licensing requirement for short-term rentals, so the regulation is entirely local. That means that your local jurisdiction has to create a regulation for short-term rentals. So, for example, there are 421 cities and counties in the state of California that have their own local short-term rental regulation. Some of the bigger ones that are held up as examples are Los Angeles, where they have 120 night cap. You're only allowed to do rent out your primary residence for a short-term rental for 120 nights a year. You have to pay a registration fee and get a license. I don't know if there are any exceptions to that. I'm not delving into each of the 421 individual cities and counties regulations. But Los Angeles is typically some of the most restricted for short-term rentals. Then we have San Francisco. San Francisco is also one of the most restricted. So you have to be a permanent resident in order to get the license, and there is a 90-night cap and a $250 registration fee. The city of San Diego is a moderately restrictive place to have a short-term rental. There's this tiered licensing system. We have the 4 tiers, one of which applies to the Mission Beach area. And there's a lottery for some of those areas where all of the licenses have already been distributed. And then San Diego County is very one of the least restricted areas. There are other cities in San Diego County that have moderate restrictions, but when you get to the outlying areas of San Diego, like Borrego Springs, then you find less restriction. And in the unincorporated areas of the county, there's less restriction. But then you have highly restricted areas like Carlsbad and Solana Beach. So quite a wide variety in San Diego. It's not very clear. You have to go to your city and look it up. And then Palm Springs, areas like Palm Springs, Big Bear, Lake Arrowhead, and Joshua Tree, which are, for the most part, those are in Riverside County. Those are the most short-term rental friendly areas in the California market. There's no primary residency required. There's a low permit fee, but don't get caught doing short-term rentals without a license in those areas, because you go to the bottom of the pile when you go to apply for a new license if you've been caught doing it without a license. All right, so then we have some short-term rental rules and regulations that we want to talk about. So the first thing you want to do if you're going to do short-term rental is look up the city website or the county website where you're located. Just go to the website and type in short-term rentals or vacation rentals into the website search bar, and the regulation should come right up. You can also use lots of other searching mechanisms. These things are pretty easy to find. If a license is required, obtain your license and then register with the local entity for payment of transient occupancy tax. You also would likely want to register with a platform that will host your rental, or multiple platforms. Some of those will collect the transient occupancy tax for you. Make sure that that gets paid. With regard to rules and regulations, some of the most interesting rules and regulations relating to short-term rentals are the restrictions and protections that are now in place for those online platforms. That's, Airbnb, VRBO, all sorts of other ones that are out there now. And federal law has this Communications Decency Act that's 47 USC Section 230, which protects online platforms from being treated as the publisher or speaker of content generated by the third-party users of the platform. So the Act, Communications Decency Act, expressly preempts any inconsistent state or local law that would try to hold those platforms accountable for things like violating local laws or breaching leases or other things that people want to pin on Airbnb or VRBO, the deep pocket corporations, for, letting the applicants, the people who are putting listings on there, for violating, local rules and lease terms. So California courts, both federal and state California courts, have consistently applied Section 230 to shield Airbnb from liability arising out of host-generated rental listings. There are other kinds of regulations that the state can put in place to hold the online portals accountable, the online platforms accountable. So California has enacted platform-specific statutes that regulate but do not impose publisher-based liability on the hosting platforms. The three elements that you have to show is that it's an interactive computer service. The plaintiff is seeking to treat the platform as a publisher or speaker, and then the information was provided by another content provider. Under those three elements, if you meet all those three elements, then the platform is protected. So you can't sue them for what is being posted on the platform. However, the California Internet Private Residence Rental Listings chapter of the California Business and Professions Code. So there's a chapter of the California Business and Professions Code that specifically relates to Internet private residence rental listings. Okay, so BMP code section 22592 requires hosting platforms to notify hosts that listing a residence may violate a lease, a local restriction, and to advise hosts to review their insurance coverage before they post on there. But it doesn't hold the platform liable for the host's conduct. Then we have the California Short-Term Residential Facilitator Act of 2025. This is our new, you may know it as SB 346. So this new section of the law, which became effective January 1st, 2026, authorizes local agencies to require platforms to report listing data. So, and there were some, I've had cases where the local jurisdiction, like the city of Encinitas, wanted to get information from the platform, from Airbnb or VRBO. I'm sorry, those are the only two that are coming to mind. I know there are many more. Anyway, the city needed that information, and they were able to obtain information about the rental activity, the short-term rental activity for a specific property that's listed on the platform. So that was happening prior to January 1st, 2026, but now California law requires all of those platforms to provide that information if the local jurisdiction opts in. So your local jurisdiction, City of San Diego, City of Encinitas, they have to create their own ordinance that requires the platforms to give them information. All right, there's some other new laws requiring platforms to disclose all fees and cleaning task penalties. Also requiring hosting platforms to issue full refunds within 30 days of qualifying cancellation. And then the other rules that I wanted to touch on are hotel occupancy rules for those for the short-term rentals. I'm going to touch on that a little bit more below, but it's important to note that there are two different sources of law that allow a property owner to remove an occupant. There's more than two, actually. But when you look at hotels versus regular rentals, you've got two distinct areas of law that apply. And short-term rentals fall kind of right in between them. So we'll talk about that in a moment. First, let's talk about the pros and cons. So a lot of the pros of the short-term rentals is that you get higher rent. Maybe not over time, but if you have a well-performing short-term rental, then you can charge per day. And if you have your place rented every day of the month, then you would get a substantially higher rental value on a monthly basis because of the per diem rate. The owner still has the right to use the premises from time to time as long as you know in advance and reserve your dates. Prevent other people from taking those dates. You're not stuck with long-term tenants that you don't get along with or you don't like. It's easier to get help removing occupants within the short-term period of less than 30 days. More on that later. And the tenant is incentivized to move out and more likely to move out at the end of the term that you've agreed to rent it to them because their vacation is over or the reason for them to use the premises ends. The short-term rentals avoid the rent cap under the California Tenant Protection Act, which only applies after the tenant has occupied the premises for more than 12 months. And then one of the pros is the potential use of the lodger eviction procedure. I'm going to come back to that. Versus tenant statutes, regular tenant statutes. The cons of short-term rental are regulatory uncertainty. These are fairly new in all these regulations. There's a lot of uncertainty with, like I was saying, with which statutes apply and what's your local jurisdiction doing. There's so many different rules that apply from one jurisdiction to the next. You're likely to have more vacancy because you probably don't have it rented for every single day unless you're in a really great area. There's higher wear and tear on your property because there's more moving in and moving out. Higher overhead for furnishings and cleanings because it has to be fully furnished, including all of the stuff in the kitchen. And you've got cleaning every, week or so instead of when the tenant moves out, in 6 months or a year or more. Property management tends to be more expensive due to the higher turnover and additional services needed. Habitability laws apply, but there's less likelihood of injury to the tenants. There's less likelihood of an escalating dispute between the landlord and the tenant relating to habitability issues for a short-term rental. And your HOA may be able to assert limitations on your ability to use the property as a short-term rental. So I think the second to last thing I said about the habitability is actually a pro, not a con. Sorry, I don't know how that ended up under cons, but not having as much liability for habitability is good. I mean, the property still has to be healthy and safe and meet the occupant's expectations. But we'll talk about long-term rentals in a bit, and those are interesting to deal with when we have major habitability issues. All right, let's talk about those lodger eviction statutes. So for true hotel guests, those are guests who are exempt from tenant protections, and fall under the definition in Civil Code Section 1865. It establishes a streamlined eviction procedure. The innkeeper may immediately remove a guest who fails to depart by the posted checkout time, but the innkeeper has to meet two strict conditions. One, the guest received written notice at check-in, and the guest has to sign this notice, stating that the innkeeper needs the room for an arriving person with contractual rights and may rekey the door if the guest overstays. And two, the innkeeper actually has a contractual obligation to provide the room to an arriving person at the time of the eviction. So the innkeeper has to disclose this, and it has to be true. They actually have to have another contract with somebody else who needs to move in. When these conditions are satisfied, the innkeeper may enter the room, take possession of the guest's property, rekey the door, and make the room available to the new guest. So if you have a short-term rental and you do have it booked back to back, then if you provide this notice, there is a pretty strong argument that this person is a lodger and you can apply this remedy. The risk is that if this lodger doesn't agree and they want to hire an attorney to contest your application of the Civil Code Section 1865 lockout, then they may claim that you've wrongfully evicted them, and they can file a lawsuit and claim punitive damages and attorney's fees. So that's no good. I'd be cautious applying that. When we look at the laws that apply, it's just a statutory rabbit hole that you go into when you're trying to classify a short-term rental as a lodger versus as a residential tenant. Civil Code Section 1940 is what we call the gateway statute to establishing which occupants receive California's residential tenant protections. So the statute's definition of persons who hire, that's a landlord, and a tenant, those entitled to tenant protections, expressly excludes two categories of hotel and lodging occupants. One, persons maintaining transient occupancy in a hotel, motel, residence club, or other facility when that occupancy is or would be subject to transient occupancy tax under Revenue and Taxation Code 7280. And two, persons occupying a hotel or motel where the innkeeper retains a right of access and control, and the establishment provides or offers central desk services, daily housekeeping, linen, and occupancy periods of less than 7 days. This means transient hotel guests who stay for less than 7 days and who remain current on charges are not tenants under California law and don't receive eviction protections. So that's a different definition. And as a lawyer, this is where we go to court and argue if we end up with a case that involves these kinds of statutes. We have a couple other interesting statutes that come into play here. I'm not drawing any conclusions, like I said, not giving legal advice, but just to be aware of. There's Civil Code Section 1940.1, which protects tenants from being required to re-register as a new occupant every 30 days in order to avoid tenant protections. So that's very illegal if if there is a hotel that allows long-term tenancy or a short-term, somebody who wants to maintain the classification of short-term rental and just makes the person re-register like they're new, that's highly illegal under Civil Code 1940.1. There's also a special rule that governs the situation where an owner has their home and they rent to a single lodger. So they rent to one person in their family dwelling, and as long as the owner retains a right of access to all the areas of the dwelling unit and has overall control of the dwelling unit, they can remove this lodger pursuant to Penal Code Section 602.3. And 602.3 provides an enforcement mechanism for the lodger governed by the statute previously cited, 1946.5. The single lodger who remains on the premises of an owner-occupied dwelling after receipt of a required notice and after the notice period expires is guilty of an infraction and may be arrested by the owner. So you can call the police and have them remove the lodger. Good luck explaining this to the sheriff. I have tried this before, successfully and unsuccessfully. Sorry, I'm blurry all of a sudden. Here, let me unblur myself. Okay. So, these are interesting rules to try to apply. And as many of you know, the alternative is what we typically handle, which are regular tenant evictions pursuant to Civil Code Section 1940, hiring of real property section of the Civil Code, which governs the traditional landlord-tenant relationship. And then other statutes that apply, CCP, California Code of Civil Procedure, 1161, and exec, which governs the unlawful detainer procedure under summary proceedings, which it's a summary proceeding in comparison to your standard civil lawsuit, but an eviction doesn't seem like much of a summary proceeding when they do actually take, 2, 3, 4 months or more, depending on the circumstances. So a few suggestions for short-term rentals. One thing that I see a lot is where the owner combines the short-term rental over the popular summer months for vacation rentals, and they do a academic rental, a school rental for the school term. So like a college rental. We'll talk about that next. This still avoids the rent cap application because the college rental would be less than 12 months and short-term rentals are less than 12 months, and may provide more stability and less vacancy for the property. So let's talk about those college rentals. College rentals are properties that are occupied by students based on the academic term, which is approximately mid-August through mid-May. The property is usually located in a university or college town. In San Diego, we have lots of universities all over the place, so you'll find college rentals pretty thoroughly throughout San Diego, at least in the more urban area. Applicable rules are conventional rental rules. So your lease has to have all of the bells and whistles, all the notices to the tenant. It has to be fully in compliance with the state and local laws. However, as I mentioned before, the California Tenant Protection Act only applies once the tenant has been there for more than 12 months. So I would still recommend giving the notice to the tenant that the property is exempt or not exempt, but with the caveat that it only kicks in after 12 months. The City of San Diego ordinance applies immediately with that 3-month exception. So a 9-month tenancy does need the City of San Diego notice. That would be required. I know that some folks do a 3-month renewal. I don't disagree with that. I think that's okay if you're trying to avoid compliance with the City of San Diego ordinance that way, but that's another discussion. All right, so the pros and cons of the college rental is that, you can charge a higher rent due to demand and multiple co-tenants. Parents often sign as guarantors, so the rent does not rely on the student's income or lack of income. You're not stuck with tenants for years. You're not necessarily subject to just cause limitations, depending on what area you're in. The tenants have an incentive and a good reason to move out when they agree to move out, because, the school term is over. There is joint and several liability. So if you have multiple people on the same lease, you don't have just one person responsible for it. You have all of them responsible for the rent. So if they don't pay the rent, you have multiple people to go after to get that rent, including possibly their parents if they've guaranteed the lease. It avoids the long-term rent cap under the California Tenant Protection Act. And then the cons are that you have higher turnover, higher wear and tear. You're governed by ordinary tenant laws instead of any exceptions under short-term rentals. You're less than 12 months though, usually, so that's good. There can still be a lengthy process to evict the tenants because you still have to use the regular summary eviction proceeding. You don't get the benefit of the possible short-term rental lodger eviction. And you're still subject to all the local and state housing regulations, habitability rules, and your neighbors might be disturbed by immature tenants, which is what I get. The majority of the calls that I get relating to college rentals are noise related or nuisance related, and that's a big one. So some suggestions about college rentals: make sure your lease is in full compliance with all state and local laws. Have restrictions on the number of guests allowed at any particular time, a specific number of people who are allowed in the home at any particular time. Make sure to require guarantors to sign on behalf of the tenants, the students, unless the students have income. And then don't put the tenancy on autopilot. You need to be aware, talk to the neighbors, drive by the property on weekends whenever you think there might be something to observe. And I think it's a good idea, although we could debate this. I think it's a good idea to put cameras on the front yard and the backyard of the property. Those are non-private areas, so areas that are not subject to privacy, the expectation of privacy. A Ring doorbell, for example, to see how many people are coming and going, because the owner may have some liability for what's happening at the property, especially if the owner is being informed by neighbors that there's underage drinking, there's people partying, climbing on the roof, doing all sorts of crazy things. The fact that the landlord is put on notice that there's crazy stuff happening on the property means that they may have foreseeable liability for foreseeable harm that happens. And so with the cameras, you then have potential evidence to support an eviction if the tenants don't start behaving better. So you have the ability to prevent large parties and terminate the tenancy with a substantial amount of evidence relating to breach of contract and possibly nuisance. Okay, so then executive rentals. Executive rentals are nice. I like these. They are usually fully furnished residential rentals offered on a temporary basis to, for example, business travelers, relocating employees, consultants, or other professionals. The term is usually more than 30 days, possibly 90 or 120 days. And it's temporary housing that's more comfortable than a hotel for somebody who's not going to stay very long. So an executive rental is often used by someone who's relocating for work, someone who is a corporate employee on a temporary assignment, or a professional who's between a home sale or a move, and insurance or displacement due to a flood in someone's residence. Applicable rules include, if the stay is more than 30 days, regular eviction rules apply. You don't have to pay transient occupancy tax if it's for more than 30 days. So oftentimes the executive rental agreement will be for 31 or more days. Standard lease and all legally required notices are typically required, so you have to just comply with all of the regulations. But you would typically be exempt from the California Tenant Protection Act because the tenancy is not going to be for more than 12 months. You would typically avoid the California Tenant Protection Act rent cap, and you would be exempt from, for example, the City of San Diego Tenant Protection Ordinance if the tenancy is less than 3 months. So some pros and cons for executive rentals. The pros are that corporate guarantors often pay the rent. There's a higher amount of rent, but less wear and tear than short-term rentals or college rentals. You have likely a more professional caliber of occupants. There's lower turnover rate than you have with a short-term rental. The occupants would have an incentive to move out when their project is complete or when their next residence is ready. They're not likely to hold over, and you're not going to be subject to the rent cap. Okay, then the cons of the executive rentals. You have a smaller market of people who use executive rentals. So usually using a property management company that specializes in executive rentals is a good idea because they would have connections to certain companies that regularly have the need for those. There's higher overhead for the property because it has to be fully furnished. The utilities are usually included in the rent. That's also similar for short-term rentals. The utilities are usually included. And that cuts down on your profit margins. So they're still subject to regular tenant protections and the lengthy eviction process that our office generally takes people through. And depending on how many properties the owner has, they may be limited to only 1 month of rent or maybe 2 if the owner owns 3 or fewer properties in the state of California. Used to be that a furnished rental, you could take the equivalent of 3 months of rent for the security deposit, but that rule has gone away. Now we're subject to a rule that says you can only take 1 month of rent equivalent for security deposit, or 2 if you fall under the exception. There's no requirement to collect transient occupancy tax, and you still may use an online rental platform because they do cater to executive rentals, but this can create some confusion with the city when they see your listing on one of those short-term rental platforms. Then you have to go to a hearing with the city and explain your whole business model. I have assisted a client with doing exactly that, and it was successful, but it took some time and some effort. So the suggestions that I have for executive rentals, you want to use a strong furnished rental type of rental agreement. That includes an inventory of all of the items in the property and the terms for the utilities. You want to verify the payment source very carefully, require a corporate or personal guarantee wherever possible, and price the unit to account for the furnishings and the utilities and the turnover and the extra management overhead. You want to take the largest security deposit allowed by law, 2 months if possible, but oftentimes only 1 month will be allowed. All right, so then we have the long-term leases. So long-term tenancies are the most common. There are many types of long-term leases. We have month-to-month lease. You could have a 3-month renewal term. You could have a 6-month term. You could have an annual term. For residential, typically we don't go longer than a 1-year term, but you can go longer than that. The status of the long-term tenancy is not based on what the lease says the term is, but rather how long is the tenant going to stay. So you have a month-to-month tenancy, but that tenant may stay for 6 months, a year, or 10 years. So for the purposes of this webinar, I'm talking about a tenant not a lease, but a tenant that has stayed at the property for at least 6 months or more. So the rules that apply, all tenant protection laws apply to this. However, Tenant Protection Act only applies after the tenant has been there for more than a year. So you still need to use a standard lease and provide any required state or local notices to the tenant, including the notice whether the property is exempt or not exempt. A little bit later on, I have a list of all of the required tenant notices and disclosures that we provide for regular residential leases. We'll just run through those just so that you get an idea of what goes into those. So pros and cons of long-term leases. The pros are long-term tenants may have an incentive to take care of the property because they have to keep living there. There's more stable income from having fewer vacancies. There's hopefully less turnover, hopefully less vacancy, lower overhead because most long-term tenancies are not furnished, and the tenants usually pay the utilities. There's usually lower property management costs due to less turnover and less effort required. And then fewer periods of vacancy. I said that already. It's better for budgeting and it's more predictable income. The cons, you get a lower rate of rent typically. There are rent caps that may apply once the tenant's been there for more than a year. There's a lengthy eviction process. You are stuck with the tenants because of the difficulty of evicting long-term tenants. So if you don't get along with them, that can be a long-term problem. Habitability issues are much more likely to escalate to becoming a long-term dispute and result in claims of personal injury if there is a problem that the landlord doesn't deal with right away. There's less flexibility to change your strategy midterm on how you are conducting your rental business. So if you have short-term rental and you want to do a college rental, you can kind of switch at any point when it's convenient. If you're doing executive rentals and you want to switch to short-term rental, you can do that when it's convenient. But with a long-term tenant, you have to wait for them to move out or find just cause to evict them. All right, so the suggestions. Oh, sorry, one more thing. A con is that lease compliance is more important due to the possibility of disputes over the long-term relationship with the tenant. So my suggestions, make sure a knowledgeable professional helps you prepare your lease agreement, make sure it's fully in compliance with all state and local laws. For properties of 2 units or more that are not owner occupied, if it's 2 units and it's owner occupied, you may be exempt, but anything 2 units or more that's not owner occupied, you need to provide. Oh, sorry, the suggestion is to provide the initial lease for only 11 months, because if things aren't working out with the tenant, depending on local ordinances, of course, but under the California Tenant Protection Act, you may be able to do a no-fault eviction without just cause within the 11 months versus when you pass the 12-month mark, called the just cause regulations apply. So doing an 11-month lease gives you a little bit of extra time to decide whether you want to stick with this tenant for the long term or not. Okay, so then the freebie, I know this is too much information to read right now, but this is part of the freebie with today's webinar, is this pros and cons type of table. It lists everything that I mentioned, not in as much detail, but it shows you the benefits, the potential income for the short-term and college rentals and executive rentals versus long-term. I know you can't see the whole thing. Some of it got cut off at the bottom. And then the pros and cons. So I think that'll be helpful for anyone who's deciding how they want to conduct their rental business. The list of legally required tenant notices and disclosures. What's on the screen here is not complete. I added a lot more as I was preparing this morning. You have the California Tenant Protection Act disclosure, local ordinance disclosures. These are all the things that we include in our lease agreements when we prepare a lease, because our guarantee when SoCal Realty Law provides a lease agreement is that it's good for a year. It's fully in compliance with the law for at least the next year. So all the tenant protection disclosures are required. The mold packet, which is a state required disclosure, bed bug disclosure, Megan's Law database disclosure, residential environmental hazards disclosure, which is lead-based paint. Asbestos is for certain properties, not all properties, but I would include asbestos, especially if it's known. If you know about lead or asbestos on your property, you are, as a landlord, required to disclose the knowledge of that. Okay, flood hazards. You have to state whether you know or don't know. Methamphetamine contamination is required to be disclosed if you know about it. Periodic pest control should be disclosed. Water sub-metering. There are certain types of sub-metering or arrangements that need to be disclosed. You also need to disclose if there are multiple units that are not separately metered and explain to the tenant how the water utility is divided. Similar for any utility that's not divided among your units. HOA rules and regulations have to be disclosed. Any military ordinance locations that may be nearby. A death on the premises. Notice of the tenant's right to pre-move out inspection. I highly recommend that this goes in your lease. Make sure it's compliant with the statutory law. There was additional language added in around 2020. So if you have a lease that's older than 2020, I would highly recommend updating your lease to make sure that that notice is in compliance. You can also serve that notice of right to pre-move out inspection later on in the tenancy. We now have the new notice of the tenant's right to a working stove and refrigerator. If the lease is for more than 1 year and you had a broker involved in coordinating the lease, putting it together, there's an agency disclosure that's required. You have to disclose broker compensation and broker representation. If the lease is negotiated in a foreign language, you have to disclose that the tenant has the right to a copy of the lease translated into that foreign language. You need to disclose the tenant's right to opt out of the landlord provided internet service. So if there is internet service provided included in the lease, the tenant has the right to opt out. And if they want to opt out, you have to give them a form to sign. If ownership changes, you have to give them a notice of the change in ownership and the new payment requirements. That has to be in writing. It's a notice of change in terms of tenancy. It's not a material change, so it can happen even while there's an unexpired term of the lease. And then if you have a building with 16 units or more, or you're a landlord who owns more than 15 units, you have to offer a positive rental payment report. So if the tenant opts in, you have to report positive rental payments to credit bureau. All right, so that's the long list of things that should be in your lease. That's all the info I have for you today. We do have some time for questions. I don't see too many questions. Yeah, there is one. All right. Can you explain or describe the protections tenants get when they've stayed for more than 12 months? Sure. So referencing only the California Tenant Protection Act, the act states that those tenant protections, including all the just cause requirements, and the rent cap, do not kick in until the tenant has been there for more than 12 months. when we prepare a lease, we still include the rent cap just cause addendum, which is, a lot of the stuff that I just went through, that whole list, including the rent cap and just cause addendum, will automatically be a part of your lease if you use the California Association of Realtors form. And I recommend doing that rent cap just cause addendum right away, even if you're not sure if the tenant's going to be there for more than 12 months. However, those protections and your addendum should state that those protections only kick in after they've been there more than 12 months. What are those protections? Well, there's a lot of things, just cause eviction. So if you look back at some of the older webinars, there's the no fault tenant no fault evictions and tenant at fault evictions, and that determines what we have to put in our notice in order to terminate the tenancy. So you have to have one of those just causes. So that's part of it. The rent cap limits the amount that you can increase the rent. Currently, the rent cap is 8.8%. I think that's probably going to go up because it goes up with the rate of inflation. So we'll find that out around June, and it'll go into effect around July 31st, August 1st. If you're going to increase your rent pursuant to the current rent cap, you want to give a 30-day notice by the end of June so that it kicks in before the new rent cap goes into effect August 1st. Yeah, I mean, I'm just going off the top of my head, but there's a lot, if you look at California Civil Code Section 1946.2, that's a big portion of the California Tenant Protection Act. And then Civil Code Section 1947.12 or 13 is another part of it. So, there's a lot in there. Hopefully that's a good explanation.